Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I'm also here to talk to you about some updates, specifically the travel ban that we are seeing right now. So I have a little more specific information about it. It was just released yesterday. The president signed this proclamation that announced a travel ban. So the name of the proclamation is restricting the entry of foreign nationals to protect the United States from foreign terrorists and other national security and public safety threats. So I know last night when I was discussing this, one of the concerns was uh, one of the concerns were there any exceptions, right? What are the exceptions? If you're here and you are applying for adjustment of status, is that going to affect you? What about if you have advanced parole? Can you still travel to those countries as US citizens? Can you travel to those countries that are banned? So we're going to go over those, and I'm going to get into a little more detail about the travel ban. Make sure you are asking your questions as well, so that I can address any questions that you have about the travel ban. So, one thing let's talk about the countries again, right? So, there are 19 countries total that are facing a ban or partial ban. So 12 of those countries are full bans, and that means that they're banning immigrant and non-immigrant visas. The immigrant visa is a type of visa that allows you to enter the United States and then become a green card holder. There are some exceptions there, and we'll talk about those exceptions, mainly in regards to immediate relatives of U.S. citizens. However, I did not see any other exceptions for permanent residents. So that is a concern there for relatives of permanent residents who are seeking an immigrant visa to come to the United States and become green card holders. I don't see any exceptions there. Let me pull up the countries and I'll list out the countries that are facing the full ban. So, full ban means that they are banning anybody who is outside of the United States who does not already have a valid visa. If they're in these countries, they will not get a visa to come to the United States. Except those that they've laid out in the document. So it's Afghanistan, Burma, Chad, uh, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen. The partial uh, bans apply to Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. Um, Partial means that with the full ban, it means that anybody who is outside of the US will not be allowed um, into the country. They will not be granted a visa, but there are some exceptions here. And I know everybody's eager to find out what the exceptions are. So, among the exceptions, so it's in section B 5. So, section B5 of the proclamation, it does state that immediate family immigrant visas, so those are immediate relatives of US citizens, spouse of a US citizen, child under 21, and unmarried of a US citizen, parent of a US citizen will not be subject to this. So they can still get immigrant visas, but rest assured, we are going to see delays. It's already delayed when you're going through consular processing outside of the United States, it's already delayed. Well, it's going to be happening here, I guarantee. They're going to be going through extra security measures and checks, and that means that we're going to be seeing a longer wait times, and as if it's not long enough. But they have listed here IR1, CR1. Those are the categories. Which means conditional residence, um, and conditional residence as well as immigrant. So they get IR1 gets a 10-year, and that goes all the way up to the IR5 categories. Now, one interesting thing that I did see here is they are saying that they will not be barred. So you could still apply for the green card, but you must show with clear and convincing evidence of identity and family relationship. That's a very, very, very high standard. So, for example, I can see where marriage is going to be a problem because clear and convincing evidence right now, you just have to show, you have to show that it's more likely than not that you have a relationship when it comes to marriage. Well, here they're saying that no, you have to show basically to a certainty that your marriage is real. If we're going to talk about marriage based cases, in many cases, we're probably going to be seeing requests for DNA tests in order to determine family relationships, which is going to make this process more tedious, longer, more expensive because you may be covering fees. So I see here a hidden provision that means it's going to make this process longer, and it's going to make getting marriage based cases, getting marriage based visas harder when they're outside of the United States. Keep in mind that this applies to outside of the United States, those who are outside of the United States and they don't already have a visa. This does not apply to any approvals before the date of the proclamation. It does not include anybody who has already gotten a benefit or a visa. So there are other types of special visas that are going to be exempt. So let me find it on the proclamation. So on the proclamation, if you want to look yourself, I'll pull it up. Okay, so under section 4, scope and implementation of suspensions and limitations, they do reiterate here that the proclamation shall apply only to foreign nationals of the designated countries, which are the 12 countries that face a full ban, and then the 7 countries that face a partial ban. And those people who are going to be subject to this ban do not have a valid visa on the applicable effective date of this proclamation, which the effective date is June 9th, and they're outside of the US. So exceptions, the suspension of and limitation on entry pursuant to section 2 and 3 of this proclamation shall apply to any lawful permanent resident. So if you're a permanent resident, it doesn't apply to you. So keep that in mind. If you are a permanent resident, it does not apply to you. I'm just checking here. Dual nationals of a country designated under section 2 and 3 of this, which are the countries of this proclamation, when the individual is traveling on a passport issued by a country not so designated. So dual citizens. If you're a citizen of that country, but you're also a citizen of the United States, as long as you travel using your US passport, then it will not apply to you. So make sure that if you do have to travel, you are not outside of the country, you are not using the passport of the country that is facing the ban right now. So special visas. So any foreign national traveling with a valid non-immigrant visa, these are temporary visas in the following categories. So these are diplomatic roles. So A1, A2, C2, C3. So these are diplomatic type of visas. Any athlete or member of athletic team, including coaches, persons performing a necessary support role, immediate relatives, traveling for the World Cup, Olympics, or other major sporting event as determined by the Secretary of State. So I guess they're trying to do a cutout of exceptions for the upcoming World Cup. Immediate family immigrant visas. So here's where immediate relatives of US citizens will be exempt: spouses, parent, and child. However, here's the caveat: with clear and convincing evidence of identity and family relationship. I know outside, if you don't practice law, you may not be aware of the standard. Well, this standard is the highest standard that you have to meet. It's not even a type of standard is in the regular immigration process. So it's going to be harder. In other words, it's going to be harder. Now, you can easily show a show a relationship with a parent or a child through a DNA test. But what that means is it's going to be more expensive, because when you have a DNA test involved, you may have to cover those fees. And so it may not be accessible to everybody to be able to show that level of relationship. They may not be able to meet the clear and convincing evidence standard. With marriage base, it gets even harder, because the clear and convincing means it is basically saying without a doubt your marriage is real and bona fide. It is the standard that is used in immigration courts is a very high standard. um, Usually you just have to show that it is more likely than not, but here you do have to show now. This is similar to without a doubt that your marriage is real. So if you both haven't lived together, you have no children together, you have no property together, maybe you just met when you were visiting the country, you met one time and you realized you had a spark between the both of you, you want to build a life together, it may not be enough to now just show that you have a desire to build a life together. So it is a very high standard, and that's, I think, where we're going to see a lot of delays, a lot of more denials, because of the failure to meet clear and convincing evidence. But another thing is we have to also this I can see where this can be challenged, because it is not uh, typical, right? It is not the standard that is stated in the law. And so it's sort of creating a new type of standard that's not written into the law. And I guess the question here is, does the executive branch have the authority to put a whole new standard in the immigration requirements that are laid out by statute and regulations? I would say no, they don't have that authority to do that. So this may be up for a challenge. Adoptions, Afghan special immigrant visas are exempt. Special immigrant visas for United States government employees, and immigrant visas for ethnic and religious minorities facing persecution in Iran. So those are the exceptions that are listed here. So as you can see, we don't see any mention of relatives of permanent residents. And so it may be a situation where permanent residents may have to get US citizenship before they can then go ahead and petition for their immediate relatives, which may be a longer road to take, because you may have a couple of years before you can become a US citizen, and that means more time and separation from your family members. Now, can you be here in the US? What's going to happen if you want to apply for asylum? You want to apply for adjustment of status. You are in the middle of applying for adjustment of status. Does that affect you? And my answer, based on evaluating this proclamation, would be no. No, it does not affect you. The reason being, it's clearly stated in this proclamation that it's clearly stated in this proclamation that This applies to people who are outside of the United States, who do not yet have a valid visa. If you're here in the US, then you can pursue the relief. And it has also stated that it's not going to affect people who are already here in the US who are seeking relief, like asylum and TPS in some cases. So that is good news, is that it's not going to affect those individuals who are already here. But of course, you have to make sure that you get legal advice for your particular situation, because I do anticipate that they are going to scrutinize. For example, if you've overstayed your visa, they may scrutinize that, treat that with a lot more scrutiny, because you're from the country that is now banned or partially banned, and in addition to that, you've overstayed. So they're going to look at that. Well, the way they're framing this is a national security threat. Now, the premise for the bans in the first place is they were looking at how are these countries helping to regulate immigration coming into the US, and what's the level of threats in their country, and what's the level of overstays. So they selected countries that either refuse to take back deportees, um, or they said they had very little security, national security regulations on their end. Um, so that's the reason. So they won't accept deported nationals back. The overstate rate is high, terrorist activity or lack of government control. However, keep in mind that the reason these countries, the citizens of these countries, are here in the US is because they're fleeing war and instability. So it's not the citizens that are a threat, it's the conditions in the country that are threatening those citizens who are trying to get to the US for safety, and who legally entered with parole, entered with uh, parole and TPS. They are here on TPS, who now don't have that because they're now ending TPS for a number of countries. So that is my summary for the travel ban. If you have questions about this, go ahead and put your questions in the comments. They did say in about 90 days they're going to reevaluate. So we could expect countries to be added and possibly even taken off as time goes by. So this is not a final list. It may expand. It may become a narrow list. Now, the travel ban, the reason why this is so disheartening is because the travel ban, uh, the Trump administration had prevailed in the Supreme Court, allowed them to do the travel ban in the last administration. So going ahead and challenging this may be harder to do because the Supreme Court has already set a precedent by saying that the government can do this. So we'll have to see if there are additional challenges to this travel ban that can, remedy this situation. All right. So now your questions. Go ahead and ask. Can a green card holder of a restricted country travel? So yes, you can travel. It does not apply to you as long as you can show permanent residence. But what I would say here is you're always, as an attorney, even though I'm not your attorney, I can't give you particular legal advice. What I can say is, as an attorney, you always have to evaluate your level of risk. So you're a permanent resident, it doesn't apply to you. They're not going to limit your travel, but you can expect to be scrutinized coming back in from a country that is banned. So you want to be very careful. For example, the proclamation did mention that they found it to be even a risk that permanent residents, they find it harder to revoke permanent residents' green card. And even though they may also pose national security threats. So you can be rest assured that if you're going to a country that's on this list and upon your return, they're going to have questions. They're going to dig into your background, and it can be uncomfortable. And if they find something, because sometimes they go looking, they will find something that they're going to use as justification to possibly detain you or send you to court to get your green card revoked. So be very careful before traveling to those countries. With advanced parole, I would say that with advanced parole, they can deny entry for people traveling on advanced parole. So you are definitely at a much higher risk of having your entry denied traveling on advanced parole to a country that's on the barred list. So, while I'm not your attorney, I can't make that decision for you. I can tell you that the risk is so high that you really need to think about whether it is worth it to make that trip. Do I need something else besides the birth abroad for my son? So you can always also get a certificate of citizenship. If you have the registration of birth abroad, that can be enough to get their passport. But if you want to also get a second proof of citizenship, get that certificate of citizenship from the USCIS. You can always give us a call and we can look at that for you. Can we apply for over 21 unmarried child, parents, green card holders? And how long does it take? 5 to 7 years. Yes, on as long as they're unmarried, but it takes 5 to 7 years, and you would not be able to, go through the adjustment of status process. It's very unlikely unless they're here at the right time to be able to do adjustment of status. Um, How long does it take to get a work permit through marriage? About 3 to 6 months. Can a permanent resident petition for a parent? No, unfortunately not. You have to become a US citizen first. If you get fiance visa approved, for how long you're going to wait uh, at the NVC? So it depends. I would say it could be another year before you get an interview. The entire process can take a year and a half right now. Can guarantee it's going to get longer as the time passes and we have more vetting in place. Can you adjust status with a pending removal proceeding? No, you do have to go back to the court and you have to get that case terminated so that it pushes the authority back to the USCIS. So adjustment of status cannot be done while you have a removal proceeding, but you can go to the court and ask them to terminate so you can finish out your process. In some cases, you can do adjustment of status before a judge. I'm approved I-130. I did an interview for I-485, but they're still pending. What can I do? It depends on how much time has passed. You can always call, find out the status. If it takes too long, about 120 days, give them a call. Can overstaying visa after AOS through marriage? If you're married to a US citizen and you overstayed even before filing the AOS, you should be fine. If you're married to a green card holder, you overstayed before filing AOS, that's where the problem is. How can you get it terminated? Do we need to hire a lawyer? Yes, I highly suggest at that point you do get a lawyer involved. Can a felony evading get your petition canceled? Not canceled, but denied, and you could be inadmissible. So get legal advice ASAP. Um, because yeah, if you have a felony in evading, it could mean that you're inadmissible. Do you need a lawyer to go to a marriage interview? You in every single instance of your life, you will or every single instance in a process, right? You have the choice to hire a lawyer or not. And it's always better to hire a lawyer. Do you need one? M- Maybe not, right? But are you putting yourself at risk? not hiring one because you don't have the expertise or the experience to go through that interview. So, would you, for example, go to court, and would you, if you were sitting, your future was at risk and you had the option to hire a lawyer to get you to go free, or do it yourself, not knowing what to do in the process and risking your freedom, which one would you choose? You would choose, I guarantee, if you had that option, you would choose a lawyer because your freedom was on the line. It's the same with immigration. You can choose not to, which a lot of people choose not to and then regret it. Need to report. Need to report a person because it's not responding for a car accident. Will that affect my case? So do a private consultation, because remember that law enforcement is now involved in the process of immigration. So, you have to think about your interactions with law enforcement now, and the level of risk that you face. Unfortunately, while I'm not saying don't call for help, if you are facing danger, immediate danger, it's time to call for help no matter what. Dial 911. If your life, if your safety, if your person is in danger, do what you need to do. And actually, don't worry about that, because as a victim, you can get assistance. That's what I do. I help my clients who are victims of mistreatment, abuse, trafficking, to be able to get relief here. However, if you have time to think about it, if you have time to think about it and consult, think strategically, take that time to do that as well, to make sure you don't regret anything. Attended I-45 interview, later got mail saying that interview was canceled. So sometimes those mistakes happen. Call to see what's going on. My husband came with I-22A. We have I-130 files still waiting. Can we apply for I-45? So I have to figure out because I'm not sure what the I-22A is. So we would have to speak with you to get details about how he entered the country. Was that parole coming through the border? Is that related to any kind of visa? Not in removal proceeding based on EOIR, but waiting on court in that regard. Can I proceed with adjustment of status? So I'm not sure what you mean by that. Get legal advice. This is what I'm saying now. Do not risk it. Get legal representation. Make sure you're consulting an attorney. Because if it's to the point where you believe that you're going to be going to court, then you may not be able to apply for adjustment of status, or the process you're thinking about may not be the best one. So stop and go to our link and get started on scheduling an appointment, because we need to talk to you. Can a citizen file an I-130 for spouse in Haiti with the travel ban? Yes. Can a citizen file? Yes. Now keep in mind what I said before. Yes. Oh, you love my dog. Yes, exactly. He's running around with his toy. um, so you can apply for your spouse to get their immigrant visa to come to the US and become a green card holder. However, what I am seeing is here, you have to show by clear and convincing evidence that your marriage is real. So now is the time to definitely get in touch with us, because we need to talk to you about what your marriage looks like, what's going on in your relationship, what kind of evidence do you have of your marriage, in order to determine the approach we need to take in your case. Because now you have to show by clear and convincing evidence, which is a very high standard to meet. We have to see if that's going to be challenged, because that is requirement is not written in the actual statute. What if you can't find a joint sponsor to sponsor spouse? Then you will face a denial. If the I-864 affidavit of support is required, you're going to need a co-sponsor if you can't do it yourself. Can you please advise about visitors visa? Not valid. They cannot find legal entry. Married 15 years. So yeah, we have to talk about that. If you don't have a valid showing of your entry, then you might have to lean on other types of evidence. So definitely get in touch with us. Can you please advise about visitors visas? So I file I-130, I-485 with paralegal. Will I be able to hire you to represent me? It depends on where you are. This is where it's important to just get in touch with us. A paralegal is not an attorney, which means that we can at least talk to you to see what's going on in your case. Because at that point where it's already filed, we have to make sure that it's something we can take, that, it's something we can fix if something needs fixing, and so forth. Uh, how long can I get work permit through a T visa? So you're looking at about 18 months right now. They do have regulations that allow for the work permit while you wait. Those are trickling out. So you're likely gonna have to wait, especially if you filed your T visa a long time. You're likely gonna have to wait until it's approved. Took fingerprints for I-360 and I-485, responded to RFE and received prima facie. What's next? So it sounds like a decision is going to be coming, and it takes up to 3 years to get a decision. So, it depends on how far in you are. Can you please advise? I answered that. I have a business and I have a 7-year asylum pending case. Can I get a green card through the business? We need to talk. It's I don't want to say yes, I don't want to say no, just because it depends on what your circumstances are. Have you accrued unlawful presence? At this time, 7 years being here in a pending process means that you're in this gray area where you don't have status, but you're not out of status, right? You have permission to be here, and that may hinder your ability to apply for a green card using your business. Can you travel on a T visa when approved by USCIS? Yes, you need a travel document, but here's what I'm going to tell you. Do you really want to travel? Take that risk now. You have a T visa, it's a temporary status. And so you leave the country, they can always find a reason to deny your entry. So you have to really think about, is it worth it? You can stay here and pursue your green card with a T visa, and it may be better in most cases during this time to wait. Consultation fee. So we have a free initial evaluation, and that helps us to not waste your time, for us to be able to determine whether there is an option we think we may be able to help you with. Then we get you into a strategy session with one of our attorneys, and that is $150 right now. I have ICE appointment to sign every year. Um, I have cat approved, and I'm so scared. So I definitely understand. However, with the cat, it's judge ordered, right? It's court ordered. You've gone through the removal process, and at the end of it, you are approved for cat. So that means that you're in a protected category. A lot of the people that are going for these check-ins, they don't have a status. They've not completed their deportation process. Now, another thing though with cat that can make it slightly uncertain is if the administration finds that the conditions in your country have changed, and so you are no longer under threat of torture in your country, they can then make a case to send you back. But you can challenge that if they now are claiming that the conditions have changed to the point where you can go back. But I understand the fear, absolutely. But I would say cat is a more it's judge ordered, versus others that are basically just deferred action, put in place by ICE officers maybe in the previous years. I'm a green card holder since 2018, but divorced. Do I need my ex-husband to file citizenship? 2018. No. So if you meet the requirements for citizenship, no. But what I will tell you here is that when you're going in for citizenship, they are looking at your files in detail. They're going right back to the start. So make sure that if you are now divorced, that you can look at your background, make sure there's nothing in your background that they can turn around and say you committed fraud or your marriage wasn't real or something like that. Because that is what's going to happen. Last administration, a lot of that happened. And so you just have to um, make sure all your I's are dotted, your T's are crossed. Is it possible to check T visa cases on USIS website? I believe they did make changes to do that, but I think people are still having difficulties. But the reason people are having difficulties is because it is such a sensitive application that they want to ensure confidentiality, and so they don't post it. Are visas overstayed with pending asylum at risk for deportation? Yes, visa overstays are considered undocumented, like anybody else who, for example, came across a border. Visa overstay does put you at risk for removal. So you definitely want to get out of visa overstay and get into another status or change your residency if you can, as fast as you can. How long does it take to get replacement green card after you got your biometrics? So I would say a year and a half. Uh, Hello, I applied for green card, case, asylum, no fingerprint. How long it take to receive green card? So I believe that the court just ordered the administration to lift the pause on asylum green card applications. And so we have to see what happens if they appeal it. But it's in litigation now and it's paused right now. But the first court has ordered them to lift the ban. So we'll have the pause. So why I'm waiting on removal process if EOR says otherwise. So I don't know what your case is. This is where you definitely have to talk to us. If something has changed, then get in touch with us. This is why you need to have an attorney, because doing it through the live for such a complex situation is not going to work. So definitely get back in touch with us and explain what's going on so we can advise further and move forward on something. But we have to hear all the facts involved. I came across the border without I-94. Can I get married? If you do not have proof of your entry getting married, it may not fix the situation through adjustment of status. Does two entries as a minor result in a permanent bar? Possibly. Definitely get in touch with us. We want to hear about the circumstances surrounding those, because in some cases, if you were taken as a child and you were placed in unwanted situations, we may be able to find relief for you, but we have to understand what your situation is. I have a proof of my entry. So proof of coming to the border is not enough if you didn't get parole, or you didn't get official parole, or you didn't get an I-94 to come in showing you got paroled. Then it's not going to fix the entry issue. But this is where it's important to get in touch and talk to us. Don't leave it to just a question on the live. make sure you are advocating for yourself first. You're looking out for yourself by getting in touch with us as the attorney or an attorney, and talk to the attorney so that you can get accurate legal advice. How long does it take to get a work permit nowadays? As I have a case pending last 6 months, I said 3 to 6 months. Even if I have a pending asylum and overstayed visa, I will still be deported. Pending asylum, not necessarily. It depends on what your circumstances are. What we are seeing is we are seeing that immigration is going and they're canceling, dismissing cases, and then arresting people when they dismiss a case, because it means they don't have any case, they're not claiming asylum, and before they can even go and try to apply for a valid process, they take them. So that's one of the things I'm seeing. Can I cancel my pending I-130 petition while I have a pending asylum? It's possible. Strategically, is recommended? This is where we definitely need to talk. How experienced are you? So my firm has been open for 10 years. I've been practicing immigration law for the past 12 years. So since 2013, when I was barred up until now. Can I call USCIS office to check on my work permit? Absolutely. Go to the USCIS website. You'll find a number there. So what if I have a date already for my final hearing? Not showing up to your final hearing means that you're foregoing relief, and instead they can find you deported in your absence. So not missing your individual hearing is one of the worst things you can do, because it gets harder. It means you have a removal order and you cannot apply for other forms of relief with a removal order. Green card holders, green card holders having banned countries passports, are they able to travel and come back? Green card holders are exempt from the travel ban, so they can. But just know that when coming back in, you may face extra scrutiny, seeing you have a passport from a banned country. If someone overstay their visa, get married to a US citizen, will that person get deported? Not if you move fast enough. So a lot of this now is about timing, because now they're saying that they're cracking down on overstays, right? People who have overstayed their visas has always been at risk for deportation, but now there's a focus on this. But what I would say is, if they catch you before you apply for immigration benefit, that's where you're going to be in a lot of complicated issues. This is all about timing, and this is where you'll hear me stressing the urgency. If you apply for relief before they detain you or before they send you a notice to appear, that means that you're likely to get the benefit than to now be in court where you can't get the benefit. You have to deal with the judge first, and that is a very stressful situation. Not to say you will not prevail in court, but it's basically you either prevail or you're deported. It's a very stressful situation. It's very inflexible. When by the time you get to court, it's very inflexible. You have specific deadlines, dates. You have procedural steps that you have to take in order to make sure that your case won't get dismissed or thrown out, or your relief will be considered. So make sure that you jump on it. You're married to a US citizen. Yes, you overstayed. It's time to act now. If your spouse, your relative, your spouse, your parent, your adult child, if they're refusing to sponsor you and they're mistreating you, it's time to act. There is what's called VAWA that allows you to apply on your own based on mistreatment or abuse. It's time to act, right? Because if you sit there and you do nothing, one, you are empowering the abuser, because if you don't have protection, they know that they can use it against you. Now we know they can, right? Because this administration, the way they're setting it up is that they're taking reports and they're looking for people, right? So they are taking all the calls to make sure that they find people. Now they have been told to find creative ways to arrest people. They've been told they're not just looking for people with criminal records. We knew that, but now it's in the open. They're saying find 4,000 people a day and take them in. We don't care how you do it, what you do. They don't have to have a warrant for their arrest. We need to see you arresting people who don't have current status, which now means people who have overstayed, which that has always been the case, but now they're putting light on that. People who've crossed the border without permission, they are now just arresting, no matter your character, no matter the number of years you've been here. So it's important to seek relief before. Now, when my clients are applying for the T visa, they get what's called a bona fide determination letter, and that helps put a stop on any removal proceedings and also offers a level of protection against even detention, because now there is a clear letter stating they that they are going through a process. Immigration denies and terminate my marriage case for abandonment. Am I going to be deported? They will send a notice to appear. So you have to act fast. If you have abandonment, we need to hear what happened with your spouse, what led up to that, so that we can possibly look at VAWA. So anybody going through a situation like that, you are not powerless. You do have the ability to look at VAWA if your spouse has abandoned you and they were mistreating you. Then you can apply for that. What about if you have school age children? So in what context? Right now, I would say we are observing that they are taking mothers from their children. It doesn't matter if the kids are in school. It doesn't matter if they have kids at home. They're just taking people in. Now, once you do get detained, keep in mind that there are ways to still get released, procedural ways to request bond. But in case of anything, while we pray that that does not happen to you, make sure you have an emergency plan in place. Make sure you have an emergency contact. Make sure you have an attorney's number that you can give to the emergency contact to call. Make sure you have all the guardian documents in place in case your child needs to have a guardian if you are detained. What if I overstayed my visa but I have a pending VAWA case? I got my work permit and travel document, then right now you should be fine. Came on F1, couldn't go to school, married US citizen, I-130 approved after interview, I-485 still pending. So it sounds like you're just waiting for a decision. All right. So now I'm going to answer questions on Facebook and YouTube. So go ahead, put your questions in the comments. After getting married to a US citizen, how soon can I apply for a green card? Right away, I would say, but keep in mind, get representation. I can't overstate this now. It's not as simple as you think, right? A lot of people have misconceptions about the marriage-based process. Make sure you are represented. Get in touch with us. We can evaluate the strength of your case and move forward, because it's all about, yes, you can apply at any time. You can apply the day after you get married, but do you have all the supporting documentation that's going to make your case strong? I'm currently working on H-1B and have BFD EAD through you and applied for a T visa waiting for receipt. Can I use BFD EAD for work if I lose my job with H-1B? Yes, you can, as long as it's current. Do you have an office in Dallas or Fort Worth? We don't have a physical office, but we represent clients in all 50 states and the globe. So no matter where you are, you can give us a call. Start with a call. You can start with the online evaluation form. So the online evaluation form, we ask a couple of questions just to make sure that your case is a case type that we look at. If we can offer an option, the online form will help you decide. It's now, keep in mind, it's not legal advice, it's not a substitute for legal advice or an attorney, but it helps us to determine whether there may be options we can offer you. So you can start there, and then once you can book your own appointment there, and please do that because we are filling up very quickly. So you can book your own appointment there, and then we will definitely talk through your case and figure out a strategy to move forward. So go to that form right now. It's in the description of the video on Facebook, YouTube. It's in the link profile of TikTok. My I-130 just got approved after 64 days. What's next? Congratulations. Just depends on where you are. What are you outside of the country? Are you in the country? It just depends. If you're in the country, adjustment of status may be an option if you qualify. If you're outside of the US, it's going to be sent to the National Visa Center, where they're going to look at whether the priority date accounts. If it does, you'll have to wait until your priority date becomes current. If it doesn't, for example, if you're the immediate relative of a US citizen, then you would be able to get processed. Although keep in mind, it's not immediate. You'd have another about year or two to wait for the green card. I-765 is already approved. I don't know if they will deny I-130 and I-485 for the name error. Please give me an opinion. I'm very stressed. So keep in mind, I'm not your attorney. I cannot give you legal advice. So do not ever take anything, and this goes for everybody. Do not take the information here as personalized legal advice to you. What I would say here is a name error should not be, it depends, right? If there's a name error, it depends on the facts involved. Does the name error somehow imply any wrongdoing? If it's just a simple mistake, then it's important to get that corrected ASAP. So work on that correction. Make sure you're talking to your attorney. There is an error with the name of my husband's mother on my marriage certificate. We hadn't noticed it before. He has already sent his naturalization certificate, the I-130, the I-485, and the I-765. So if the name error is on the original document, get that corrected, and then show the correction to the officers should you be called to an interview. You can also explain that to the officer if that does come up. But get that original document corrected. I got arrested for reckless driving due to speeding, which I got a disposition before I got my 10-year green card through marriage. Will I be flagged when re-entering? I was never convicted. So it shows that they already know about this. A lot of the green card holders that are being detained, they have new criminal cases that happened after they got their green cards, and so that puts them at a bigger risk. If you were approved after they evaluated that, you fully disclose that to them, then they've already told you that you can qualify for the green card. They've given you the green card. It shouldn't be an issue. But if you have any additional doubts, this is where you definitely should talk to an attorney. You can always give us a call. How can I get your number? You can go scroll to the top of this chat feed on TikTok, and you'll see the number at the top. You can also look at all my videos on my main page. You'll see the number there. You can also go to the link in the profile, go to the website. You can fill out a form. You can schedule your own consultation, or you can just click on the call number, the number on the website, and it will call the number. We answer our phones 24/7, by the way. So you call, you will get an answer, and we get started right away on doing the evaluation. What about the new crackdown on visa overstays? So we've always seen people with overstayed visas have always been subject to deportation. However, with now the crackdown on overstay, where we might be seeing them tapping into databases to find those people and seek them out, go to addresses to seek them out. So, as I said before, nobody's really safe. What I would say is the thing that does determine whether you have uh, an upper hand in your process is are you actively seeking relief, are you actively getting legal advice, and strategizing based on your particular situation. Can I travel on advanced parole? I'm very conservative right now about traveling on advanced parole. It just, it even depends more on your situation. But traveling on advanced parole, keep in mind they can always deny you entry, and it's very nerve wracking coming in because they put you in secondary inspection. I amended my return to meet the gross income as an affidavit of support spouse. Can this affect the case? If you did it, if you amended your tax return and the amendment is correct, then and you now meet the affidavit of support requirements, then that should be fine. I got my two prima facie for 180 days valid until August 2025 for my VAWA case, almost 2 years overstayed. Keep in mind, if you this is what's happening now. Those who've overstayed, who have you're not pursuing any process or you don't qualify for anything, you're at the top of the priority list for removal. Unfortunately, this is what's happening. I mean, everybody is really on the chopping block at this point. But what I would say here is that if you overstayed, you're in the middle of a process, though. They are not looking for those individuals. They're looking for individuals that have no process, who overstayed, who are here. You can overstay. If you end up overstaying while you're applying for a process, that's permitted. What's not permitted is not following a legal process and having an overstay. That's where we're going to be seeing a lot of the targeting. So, once again, make sure you're getting in touch with an immigration attorney. That's what we're here for, to figure out what the best options are for you going forward. Is there a ban on TVs or work permits? Not right now. They haven't announced one. They are working on one for asylum seekers. So we have to see if they're going to make changes. Now, there is a law before Congress that has passed a House of Representatives that will now put fees on certain types of applications. And it will, if approved by Senate, it will make work permits 6 months. Every 6 months, you have to renew a work permit, and it's about $550 for a work permit, $900 to appeal a court decision. So we are seeing that could be a possibility, in addition to them prohibiting asylum seekers from working. So we have to see where this goes. This hasn't been officially announced, but we know that they're working on it now, and it wouldn't surprise me if they restrict other categories as well. But here's what I say: this is where it's important. Timing is important, guys, because the people that are going to face repercussions are those that wait right now. It's not no time to wait. It's time to get on it and submit your applications ASAP. All right. Okay, so that's gonna be it for me tonight. I'm actually gonna head over to Instagram because I wasn't able to get Instagram on the live tonight. So I'm going to go ahead, go on Instagram. You can, if I haven't answered your question, you can ask it there. Look in the profile, you'll see on TikTok, you will see the link to Instagram. You can click that to join me on Instagram. I'm going to be there in a quick minute. Or you can go ahead and um, you know, go to Immigration Lawyer Sharifa on Instagram and you'll find me there. Don't forget to like, subscribe, follow, hit the notification bell. My YouTube channel is Getting the Green Card, and I do release long form videos there that talk more in detail about different things in immigration, such as VAWA, T visas, the current policy changes that are occurring. So make sure you also subscribe there. And by liking, subscribing, you are also sharing this information with people that need this information for empowerment, because there's a lot of misinformation going on out there, and that will cause people to think they do not have the power to win their cases, to win relief, to win their place here in the United States. So make sure that you are sharing, you are liking, following, subscribing, so people understand that there are options out there. All right. Have a good one, everybody. I will see you tomorrow. In the meantime, stay safe, take care, hang tight, and let's walk by faith and take action. All right. Bye bye. Thank you, Kay. How long can you get bona fide determination letter after filing a T application? So right now we're seeing about 2 months or 2 to 3 months, but after we get the receipt notice, so after they've received it, 2 to 3 months after. All right. Have a good